The Constitution is a collection of 27 amendments specifically designed to protect our individual rights and liberties. This means that the government can't overstep their boundaries and force their power on anyone, regardless on who they think they are. Within these 27 amendments are the fourth, which gives people the individual rights to be secured in their own houses, their own property, and cannot be unreasonably searched. It means that cops can't just show up at your doorstep and tell them that they want to check your house just because. It protects us from that overstepping of their government issued power. It means they can't do whatever they want to us just because they have a badge on. Which is a situation that we find ourselves in with Sheriff Ray Horn. See, Sheriff Horn was on patrol at night and saw a pickup truck that made him feel suspicious. The deputy decides, even though that the driver didn't break any laws, that he was going to run their license plate and issue a standard traffic stop. And he does just that. He runs the standard procedure, checks her ID, her insurance documents, takes her license and runs it through the system. Everything was a normal police stop. She didn't break any laws, so the deputy let her go. But she comes back later to sue the sheriff's office for a breach of her civil rights. She argues the fact that it was unconstitutional to pull her over simply because the vehicle's owner had a bad record behind his name. See, the record of the person that owned the truck actually had a suspended license, which is what tipped the deputy off as to it being a suspicious vehicle. The sheriff argues that because Deputy Horn has plenty of experience and has this intuition enough to stop suspicious feeling or potentially dangerous looking vehicles, that it's not a big deal that he stopped her to pull her over. More especially because nothing happened. He let her go like nothing was wrong. No ticket was issued. There was no summons. There was no violence. You see, there's a very specific Supreme Court case on this that I actually did a personal case study in for a judicial systems class. The Supreme Court case is called Terry versus Ohio. You see, in this case, the officers saw Terry and a couple of other men scouting out a store, looking like they were about to commit a robbery. Because he was suspicious, he decided to search Terry's person and ended up finding a gun, and ended up arresting him for the illegal owning of that firearm. The Supreme Court ruled an 8-1 ruling, which is a very overwhelming ruling, that the search was legal. He decided that during the situation, the men were going back and forth, looking into the store glass, trying to not look suspicious, but looking very suspicious to the cop, which is what made him search Terry. In this case, it was specifically established that while yes, we do have the Fourth Amendment, it's not foolproof and it's not bulletproof. If you look like you're going to do something that a cop needs to stop, they can and do have the right to search you in a limited section. You see, they can't just walk up to people with any sort of pre-made prejudice or bias and said, "Let me search you." In this case, Terry looked like he was going to do something bad with the intent of breaking in and robbing that store. So the cop did something about it. And this was a good search. This specifically stopped a potential crime that he was about to commit, and Terry was found with a weapon on him, even further leading to that potential of him committing a robbery. This lady that was driving doesn't have that sort of scenario happening to her. She wasn't charged with anything. She didn't have any sort of weapons or any alcohol while she was driving. She wasn't arrested or accused of anything. She was let go with a legally committed search. This court case specifically tells cops that if they do find suspicion, that they are allowed in a limited context to search them. The cop, Sheriff Ray Horn, definitely had the suspicion behind him, seeing as the license plate of the driver was suspended. The suspended license could have easily been the person who actually owned the car driving, which means that he would have been driving illegally. This alone should be enough to let him search the vehicle. That's plenty. He would be breaking the law. In my eyes, she has no case against this sheriff's office. He was doing the job that he was given to do. You see, a cop's job is to protect the people in the public areas and to enforce the law and to prevent crimes from happening if possible. If you take a cop's ability to prevent crime away from them, they can't do anything until after the crime's committed. If this vehicle was being driven by the woman's uncle who had a suspended license, and he did get into a car accident and fatally killed someone, not only did he cause an accident that was fatal, but he wasn't supposed to be on the road to begin with. This simple stop to make sure it wasn't a person with a suspended license driving could easily have saved someone's lives if it really was that person. You see, this sheriff's actions only took like 10 minutes out of her day, and it's easily a lifesaver in some circumstances. There was not only no law broken, there was no breach of her civil rights, and the Supreme Court case, clear as day, tells you that cops can do this with a reasonable suspicion. Sheriff Ray Horn did a good job, and not only that, he performed his job at an official level. He did it swiftly. There was no accidental violence. There was no loss of life. It was a perfect stop with a reasonable circumstance behind it. And it was a quick stop that only, a couple minutes just to make sure that she was indeed a legal driver. That's more than enough evidence to say that he did a good job in doing his job. And this sheriff did the right thing.